Without further delay, I am honored to invite Advocate Neelambaran sir to join us and take his place as the distinguished judge for today's Moot Court session. Additionally, I kindly request Advocate Sanjay Sarraf sir to accompany him. Please, sir. Thank you so much, sir. Now I kindly request our court officers to please take their seats and start with the program.
And this is Rajat Bhardwaj, the co-counsel, and this is Abhishek Godse, the researcher. Counsel seeks permission to invoke the jurisdiction to the Honorable Court.
Yes, okay.
The appellant humbly submits this memorandum for the petition filed before this Honorable Court. The petition invokes its rooted jurisdiction under Article 2 to 6 of Indian Constitution. It sets forth the facts and laws on which the claims are based.
Issue number 3 is whether the prosecution's case infringes Raj Chaudhary's right to freedom of expression as guaranteed by the Constitution under Section 19, subsection 1, subsection A, my lord. The first point I would like to make here is that, my lord, in the landmark case of Ramesh Thakur versus the Union versus the state of Madras, Supreme Court clearly emphasized on the importance of the free speech, which is essential for the democracy, my lord. And Raj.
Should I ask some questions? This petition has been filed under Article 226, correct?
Yes.
Yes. So this is a matter is relating to 499 of the case, IPC. 499 of IPC?
Yes.
Yes. You have challenged that this is a provision under 490, the information piece. How could be available at Article 226?
Can you please report
How this petition is maintainable under Article 226?
Because, my lord, actually defamation, because as such these statements were not of defamatory nature, my lord, and hence my lord, special appeal under section 226 as you cited should be Raj Chaudhary should be allowed to appeal, because the lower court's judgment the lower court judgment did not consider all the relevant evidences that were present at that time.
I do agree that. I want to just say that the basic principles of law. The petition is been filed under Article 226. Correct. That's your learned colleague has made a statement that this petition has been filed under Article 226.
Yes.
226 is a writ petition.
Yes, fundamental.
226 is the fundamental. Whether this petition has been quashing the lower court proceedings, the lower court has granted that there is a punishment.
Yes.
Correct?
Yes.
So that has been filed by way of an appeal.
Yes.
Yeah, appeal.
Yes.
So quashing that FIR, what is the provision under the law? If the FIR has been registered.
Yes.
So what is the relevant provision for quashing that FIR? Before filing in a high court, what would be the relevant provision under the article? You are saying that 226 it has been filed.
Yes.
So please verify that whether it is Article 226 or 482 of the CRPC.
I'm sorry, my lord. I would seek the court's permission to grant me some time to come up with this, my lord, because I have to research on this a little bit.
Sure.
Thank you, my lord.
Under Section 499 of the Indian Penal Raj's statements were an exercise of his fundamental right to freedom of the press. However, we contend that his allegations went beyond permissible criticism and amounted to defamatory statement with no factual basis, thereby damaging the reputation of Sonia Rao and breaching the legal boundaries set forth by the Constitution and statutory law. Section 499 of the Indian Penal Code defines defamation as
Article 19 1A, there is the freedom of speech and expression. Is there any restriction imposed? Under any other provision, there is a restrictions imposed, as you said.
Yeah, restrictions are imposed under Article 19.
What are the restrictions? Mainly, what are the restrictions imposed?
The restrictions are imposed based upon when there is the question of integrity of India, when there is defamation, when there is a harm to public peace and harmony. So these are few of the restrictions which I am telling right now. But the more restrictions are also mentioned under this article.
Have you come across the recent some full bench judgment of the Honorable Supreme Court in this matter?
No, sir.
Have you made any research to this effect?
The recent judgment.
In 2023, there is a 5-bench
I would like to take some time. I would have to discuss with this.
Yes,
with her.
please discuss with that. There is some judgment in 2023, which tightly by referring to the Subramanian service case and the Rajagopal's case, there is a 5-bench constitution bench has been formed, and there is some discussion in regard to the reasonable restrictions of 19(2), whether it can be extended to the other fundamental rights or not.
Yes.
Have you come across this judgment?
So we have read, but we are not well versed with the judgment. So I would like to just take few
Please,
minutes.
please.
Thank you, sir.
Council seek permission to address the issue number 2, which is whether Raj statement amount to hate speech under section 153A of the IPC.
You are referring to page number?
Page number 16. It is humbly submitted before the Honorable Court that in the case State versus Raj Chaudhary, the core issue is whether Raj Chaudhary's statement during the televised
We have to correct it.
Make it correct.
Yes, sir.
Your submission is over.
So,
Can I ask one question?
yes, sir.
Yes. Whether such statement, you can just discuss it there. Whether such statement, whether the hate speech has been made. If I make that appellant to withdraw the statement, the person was made a statement, but he withdrew the statement later. Whether it amounts to constitute a crime, an offence under 499.
Yes, my lord, it can constitute because after whatever the opinion has said, it cannot be taken back. The harm to the reputation is already been done.
According to you, that means you are the appellant, correct?
No, we are defended.
Defendant, you are responding to that.
Yes.
So that once the statement has been made, they made it, unconditional apology has been made, then can you accept, the court can accept that unconditional apology?
The court cannot accept that unconditional apology because hate speech is there. Public harmony is also disturbed. We can say the political group is also being affected, as well as religion comes in between. Mob lynching accusation is not a simple accusation or which we could easily go away with. It involves religion, Hindu community, Christian. It's not specified in the issue, but they are at the priest. So there is violation of their right, and for the same, the religion comes in between, and therefore that religious group is also affected, and violation and violence can be there. So there is potential risk of that.
And which paragraph you are referring to memorial?
I am referring to page number 20, para number 3, defamation point.
Yes. Para number 4.
Yes.
Yes. I am talking about evidence, not the citation. What evidence you have? According to you, that there are substantial evidence has been needed to establish your prosecution case.
Prosecution is right.
According to that evidence, you are saying that there is an evidence has been placed. What is an evidence in this paragraph which you are relied on?
Evidence is not being placed. The thing is they lack evidence, and that's why we are coming here.
What is it? Just to read para number 14, page number 14.
Which paragraph number?
Para number 2.
Evidence and context of Raj Chaudhary's statement.
Yes.
Raj Chaudhary accused Sonia Rao of corruption and inciting violence without providing any substantial evidence. The statement
appellant is well known that according to this section, the appeal should be made in the sessions court, but in the moot problem it has been given that Raj has the legal right to approach the Honorable High Court because of the seriousness of the charges and significant legal questions mentioned. Hence, we approach this court.
Proceed.
Your Honor, the case revolves around the right to freedom of press, which is an inherent part of right to freedom of
To start with the pleadings on the third and the fourth issue. Much obliged. Your Honor, the prosecution case infringes upon Raj Chaudhary's fundamental right of freedom of press, which is clearly guaranteed under Article 19(1)(a) of the Indian Constitution. Your Honor, freedom of press is absolute, however, a subset of the broader perspective of right to freedom of speech. Your Honor, in the democratic country, it has the holding of those in power accountable. Just like Raj Chaudhary in the broadcast of the TV, national TV. Your Honor, Raj Chaudhary's fundamental right has been violated, due to which I would like to quote cited of
Restrictions which is imposed. So what was the five-bench judgment that held that? Whether that, just to precisely, I will just ask this question. Whether the judgment, the Article 19 subsection, sub-Article 2, reasonable restrictions imposed, whether that's 499, that the Article 19(1)(a), that is the freedom of speech and expression, whether can the court held that, whether the court has held that it can be extended to other guarantees, the rights which has been guaranteed, or they are restricted to the only that in 19(2). And you suggested that whether that restrictions can, the court can interfere by taking that into consideration of the other articles.
No, sir, it cannot refer to the other restrictions.
Yes.
It was totally on the head of.
The restricted, the reasonable restriction imposed, according to you, that the reasonable restriction has been imposed only to the provisions which has been made. There is a threat to the national and sovereignty, correct?
Yes.
Not other than that which has been mentioned. Do you know that which has been, where it has been brought, this constitution? And have you read that judgment?
Yeah, I have read that judgment.
So where it is mentioned anywhere in that there is a Article 14 subsection 2 in the Irish constitution which has been brought at the time of the drafting committee. It has been mentioned in that somewhere in the judgment in para 13, correct? It has been mentioned that there is this Irish constitution wherein the word which has been used, that is the defamation word is also, it has been included in that particular article, the draft committee, correct?
Yes.
So what is according to you that what was the final outcome of the judgment in Kushal?
I would like to cite the case of Kishore.
Yes.
So in this, the Constitution bench held that the freedom of speech of public officials cannot be restricted in the favor of another person. Fundamental rights, however, they held that the state has the obligation to protect the fundamental right to freedom of speech. Even if it is against the non-state actors such as other private persons. So the Raj Chaudhary is the prominent anchor, so he is included as the other private person.
So that there is a protection guaranteed under Article 19(1)(a) protected.
Yes.
They have been that's protected. Sure.
Thank you.
I would like to state the facts. Lordship, the case originates when a news was broadcast on TV by Raj Chaudhary, an renowned TV anchor known for his fearless reporting and sharp commentary, had sparked outrage with his on-air allegations against Sonia Raut, the leader of opposition. The incident unfolded during a prime-time news debate focused on governmental corruption, a topic of immense public interest. Raj, the anchor, known for his candid approach, launched into a scathing monologue accusing Sonia Raut of corruption. Raj, known for his candid approach, launched into a scathing monologue.
Do you think that our Indian citizen doesn't have any such constitutional right?
come again.
Sorry, can you hear me?
Yes, yes. Now
Yes, yes. Do you think that the Article 19(1)(e), the Constitution, the speech and expression, is it not an exception to that? The defamation is would be an exception to the guarantee, the constitutional guarantee which has been Article 19(1)(e), which has been guaranteed by that. Isn't all the citizens has they have that means such kind of that the immunity, but we say that. Do you think that means making the statement before the media or any public that amounts to or criticizing a public servant that amounts to a defamation? In that case, what would be that our democratic system? Our democracy, unless that the criticism is not there. If it is a why that means our country is a democratic country, but we say that. What is the reason for a democratic? Because opposition is there. Yes. If there is no opposition, what would be the situation that our country? So, do you think that this if this guarantee, the constitution does not permit such a guarantee, then what would be that our country? According to you, what would be that? Do you think that means this it should be struck down the 19(1)(a)?
No, my lordship, 19(1)(a) gives the freedom of press, but to say what is right and which is to say what is right and which is true facts, that what the press is coming out should not be malicious or malified. That should be true and bona fide.
But the lower court has been already held that. The lower court has been already held that there is a substantial evidence to prove that the Raj's statement is not malicious and not a defamatory nature. How you are going to the prosecution to say that no, it is still it's a defamatory statement, and how it will be affecting the public at large?
Sir, I think
Yes, sure. Please.
There are not Article 19(1) surplus A is providing immunity, but there is no any proof or any evidence that our client is did such wrong. There is no any evidence or there is no any proof. Shall I proceed?
Who has not made an evidence? I didn't follow. Can you just repeat? I didn't get you what you said.
Sonia Rahul
Yes.
did malicious practices or corruption or such wrong things is
Okay.
there is no any
no evidence as such
Yes.
placed on trial court.
Yes.
Correct. So the statement is a court statement which has been made.
Yes.
Please proceed.
Third issue was that whether the procedure's case infringes upon Raj's fundamental right to freedom of press guaranteed by Article 19(1) subclause A of the Indian Constitution.
It is supporting the appellant's case.
So what about that? What the submissions which has been made that you have cited some judgments which is supporting them, not in your
All judgments, Your Honor.
What about your submission to that? Why there is no such judgment is available in your favor? Or that means you have made a deliberate attempt to support the opponent?
Lordship, freedom of speech is a fundamental right in many countries. Does have some exceptions where certain types of speech are not protected. These exceptions typically include the incitement or violent speech that directly encourages or incites imminent violence or lawlessness. And defamation is also one of the part of it. The false statement that harm the reputation of another person. Then providing the immunity, there is no any proof or evidence available that Sonia Rahul did corruption or mob lynching, so it is clearly a defamation case.
Your Honor.
Raised by the appellant saying that the judgments you have cited, the judgment you have cited which is not supporting you, it is supporting the other side. Are you going to suggest that this judgment has been wrongly computed in this competition? Or you are drawing the judgments, or are you supporting the
The order passed.
Interpret that. Otherwise, you have to interpret that this case is supporting you. You have to make that a submission that this deputy is supporting you, not that it is an incorrect statement has been made by the take that Ramesh Thakur versus State of Maharashtra, State of Madras, page number 11. Yes. How it would be helpful for you?
The order passed by lower court was overturned order, where we do
Overturn or it could be overturned. According to you, that this is an appeal. You mean to say that this the lower court's order to be overturned or it's already overturned?
it is already overturned.
Okay.
We don't need an overturn order. We need the
Please explain me whether what was the lower court's order?
lower court's order was
Whether it is that the
to
accused has been acquitted or it has been convicted.
the accused has been convicted.
Accused has been convicted. Who had filed an appeal?
The accused has filed
The
an
accused has filed the appeal. Correct. So then are you supporting him by citing his judgment?
No, the thing about supporting this is that we don't want overturn order. We want direct justice from.
You are supporting that the trial court. That's what. Once it is convicted, that you are saying that the trial court order should be sustained. It should not be overturned. Correct.
Your Honor, they have mentioned in their pleadings and the memorial too that you overturn the judgment. Alright.
Appeal under 374(3), my lord, reading 226.
With that is direct, I would like to draw the Honorable Court's attention to the provision of 419, Section 499. Section 499 reads, whoever makes any imputation intending to harm the reputation of a person is said to defame that person. In brief, Your Honor.
Have you received any copy of this?
Other side.
Other side. Please run to the other side.
Yes, Your Lordship, this in trial court, this judgment was not brought before the trial court. The requirement that under section 153 consists of oral testimony of certain witnesses who claimed that the appellant was telling others that the army personnel have been committed and the freedom of press extends to engaging in uninhibited debate about public issues and events. In this judgment, they meant that you can discuss matter in public. If you can refer to page number 33, this is para 61. Express are controversial. Second, it is just, Your Honor, can I have 2 minutes of your time to finish this? Thank you. Sure. Just last sentence. It is important to have a quote that somebody had said, the democracy is in threat or the world is threat because the people who know the truth do not speak up. That's why you have a whistleblower act. We encourage people, come forward, even if you suspect something, please speak. My lord, if this judgment is not overdone, what impact will it have? This is, if you ask me, with all due respect, this is misuse of power. If this passes, they were not with, they were qualified statements, they were not with malice. The fact that Sonia agreed to come because she perceived this person.
I would like to bring a register. the petition filed is not maintainable under section 226, article 226, as it is designed to address the issue involving violation of fundamental rights. Also, as this case is of defamation, that is a cautious action, like a civil wrong. So I request the Honorable Court to not to entertain such appeal. Further, my grounds are, the documents, they say about the verification between CEOs, and there are many other things that we will be covering up in the reported round. So we have certain other things that we want your attention to be because of the mock lynching topic that we discussed. It will be dealt by my co-counsel.
Second, saying that it's a bona fide. The statement which has been made bona fide. So according to you, that the statement is been bona fide, or whether it is what within the parameters of the substance.
So
There are defamation, there are exceptions. Exceptions means it is defamation is not applicable as a defamation. It is not a defamatory statement. So there are exceptions as been carved out in this provision. So that is why that the appellants have been raised this legal issue by citing them to the judgments, saying that this is an exceptional case. The statement which has been made, that gave speech which is right, that is in a good faith. It has been made by the substantial evidence which is being offered. So, what do you want to say that? Whether that evidence is sufficient to prove their case?
That evidence, we would like to see the evidence that they are talking
Yes,
about.
sure.
We would like to
So,
see
this is
that.
a question we need to answer to that appellants, because their case is, they have raised this legal issue only. That is, according to the appellants, this is a legal issue. If there is a legal issue which has been raised, if it is substantiated, then they will succeed the case.
Yes, but
Rather than the factual aspect, they have laid upon that relevant provision from this Act. 499 subsection, there is a clause, the exception 2 and 9. You need to answer to that, whether that exception is applicable to this present case, the factual circumstances of the case or not. If it is not, explain.
I would like to go back and come back with the answer. My co-counsel will now.
Second is establishment solution. The third issue, whether the prosecution cases emphasis upon Raj Chaudhary fundamental right to freedom of press guaranteed by Article 91A of the Indian Constitution. Your Lordship, even though the appellant decided to raise awareness, as they said, it's in good faith, but it should be subjected in a manner which is but the manner in which it was to be subjected to the public should be taken into consideration. As you can see, there is a code of conduct, reporter's code of conduct. It should follow. Your Lordship, now I will humbly submit Exhibit 1 and B. The second is establishment solution. The third issue, whether the prosecution cases emphasis upon Raj Chaudhary fundamental right to freedom of press guaranteed by Article 91A of the Indian Constitution. Your Lordship, even though the appellant decided to raise awareness, as they said, it's in good faith, but it should be subjected in a manner which is but the manner in which it was to be subjected to the public should be taken into consideration. As you can see, there is a code of conduct, reporter's code of conduct. It should follow. Your Lordship, now I will humbly submit Exhibit 1 and B. The second is establishment solution. The third issue, whether the prosecution cases emphasis upon Raj Chaudhary fundamental right to freedom of press guaranteed by Article 91A of the Indian Constitution. Your Lordship, even though the appellant decided to raise awareness, as they said, it's in good faith, but it should be subjected in a manner which is but the manner in which it was to be subjected to the public should be taken into consideration. As you can see, there is a code of conduct, reporter's code of conduct. It should follow. Your Lordship, now I will humbly submit Exhibit 1 and B. Stated that of non-lynching, which is a serious crime, which they do not have any verification to it. Still, they are broadcasted in a public domain, which can create enmity between the public and the clients.
X, which is 1000 and damages for defamation.
Just answer the question.
I am reading the first statement. The statement made by Chaudhary genuinely consists fair comment. So this is a clear-cut admission in the pleadings from the opponent side that it is a fair comment. The first thing is first admission. There are several admissions here, and also can you see the last para on the same page? Discussion. He may have a duty to ensure that the content here meet the certain standard. They are just talking of his responsibility as a host, my lordship. Failure to exercise this duty could still render him liable for defamation, even without direct. Yes.
That has been read by the respondent.
Yes. As per section 5, there is a responsibility for the host, but this was a live telecast lordship. In live telecast, it cannot be regulated in case of live telecast. That's
Section 5. Have you verified that the before the airing that this particular program?
regarding verification. Yes. In the trial court, we have established lordship that we have established the cogent evidence from the.
Only in that, you have called a public figure to your forum where you're discussing about governmental corruption. The issue should be of governmental corruption and not to the opposition leader, where you just completely mismanaged or spoke randomly and.
Should please take their seats.
Yes, it was a good debate. All of them, whatever that means, their submissions was very focused. I can say that it is focused. Some here and there is some mistakes are there in the pleadings. But overall, I would say that yes, it's a very good approach was good, and they are all are confident. Especially some good. I think you are also good enough to that. The last contestant also, that means that focus, and they have submitted that how these statements. See, when they are making to the court, the first you are making the what is your fact. First 10 minutes, 10 seconds, what we can say that. First 10 seconds, then you will have to make your case. Whether the petition should be admitted or dismissed, that the fate will be decided in first 10 seconds. So you got an opportunity for the first 10 seconds. That should be, you should not look on the paper. You should be, petition will be considered and it will be admitted. If the 10 seconds you are not in position to make the submissions properly before the court, then it will take a long time to get your petition admitted. So the first 10 seconds is the golden hours, what we are saying in the golden hours in that the cyber crime. It's the golden seconds, what we can say, the golden seconds. The 10 seconds we are making the submissions, the forcible submissions, it should be thrown that it's to reach to the court. Yes, this is a matter, this is the case, I have challenged. So only few of them has made the proper provisions of the law. So whenever you are making the submission, this is an appeal under section so that appeal has been filed. Some of them has said that this is a petition under article 226. So the 226 is exceptional, that is a writ jurisdiction. The writ jurisdiction is always the bench or the public body. But here in this case, this is an appeal. Arising under an order passed by this trial judge. It's an appeal provision. Under the CRPC 372, there is a provision which has been cited by one of the participants just to rightly point out it. But he has pointed out it that, but while writing that he has mentioned it's the 226. So that he has made a submission, but by making that means the wrong provisions of law, that is not the, it is not the end of it. Making
Continue, sir.
there is a making that means the wrong provision of law. That would not mean that to dismiss your petition. It is the court understood that you intended to say. So then that is not to be considered as a, yes, there is a wrongly mentioned the provisions of law or wrongly cited the judgment. There is some pleadings, some mistakes. But to try to avoid these pleadings mistakes, that is the main foremost. The opponents, sometimes it has been appellants has been pointed out that the respondent has made some statements which are against them. So you see that if some client has approached you to file a case to defend the case, then the pleadings are made, the statements are against them. Then what would be the fate? What would be that you have to answer to the client? So, making the moot courts and everything, that means you have gotten a platform to, that means it is a what is called that is a pre-arguments or pre-practice. When you start coming to the court, that means you need to take that very seriously. Yes, whether I made that. So why, once it has been relieved or it is out of your hand, it will go to the court or it will go to the other side. So what that means, they are taking an advantage of that your own mistake, rather than probably that other side doesn't have any case. But because of that means got that some mistakes on your part, the other side is taking an advantage of that, then they may succeed the case also. So be careful that. Understand and picturize the something else, but not in the study books. So I think then we need to make that, picturize that. This is the best example how to learn, how to make it, picturize it. These are the study materials that you have to make it, picturize it and make it a live script. The director who made that means the script for the movie, you are also, all are now after become the lawyer, that means all of the script writers. You will start that reading, so then while script writer, one that speaker and another speaker, all the three groups they made the study. Yes, the one researcher they means bring that means all materials, the speakers, then you identify that means who is going to take that this part, who is going to take that other part. So this is the systematic way that in the future also that this would be that means one of the what can I say that step, the first steps that the pre-practicing step. So I would say that all the best to everyone, all the future endeavor also that we
Thank you for your suggestions.
Yes. You can ask any question. No question at all. You can ask the question, there's no problem. That I will one day I will come here in that. I told that I will make a, yes, it's possible, that means I will make that I will share my experience, but yes, please sir.
You heard all the teams, the three teams, right? All of them were equally good, and as you rightly said. But still, if you had to pass a judgment, because everybody made an appeal to you. So, if you could just say which one, what would be your decision? So, as students, even that would be learning for us.
Yes. See that thing is that after the hearing of both the parties, I would say this. According to me, that means fundamental rights under Article 19(1)(a) must be protected. Speaking to the media or any social media or whatever you feel, that means I have a right of freedom of speech and expression. If that right, if it curtails, then our democracy has been put an end. That has comes to an end, what I say. So I would say that, but it should be with a reasonable restriction also. You should not cross the limit. If you say something, that means it should be thoroughly verified. Without any supporting documents, then if you make the statement, then we follow the 499 or any other provisions, not only for 153A, 124. There are so many provisions in the IPC also, which I think you all read this Kaushal, state of Kaushal versus state of UP. I think only one participant who has cited that judgment. That is a very important judgment. So this is one more. I forgot to that means to tell that everybody, all the pursuing lawyer or the law graduate should be one day one judgment should be read, because now all these judgments are in online. It is in the Supreme Court. The Justice Chandrakant has been made the platform to read everyone to see that in the different language. They are in the pursuit of, I think, different language. So whatever the local language also you can read it. Yes. So that everybody, this will be take as a pledge. Take as a pledge. Everybody should read that one judgment one day. Whatever that, civil, criminal, whatever. See, that judgment of 5-bench judgment is enough to study that so many judgments has been referred. Just like a Gopal Subramaniam Swami's case, Gopal's case, there are Managandhi case, so many cases has been prevailed. So what will happen that the latest judgment shall prevail. So whenever you are researching, you first refer to that what is the latest judgment. Rather than, because what happened that this scenario has been changed because of the circumstances, and then all this law has been changed time and again. So you should know that means what is the present law in land. Otherwise, what happened that you are going to cite a judgment which it's an old version. Other side saying that sorry, this judgment has been already overruled by the Supreme Court. This is the latest position. So what will happen that whatever you are argued and whatever the research you have did, so that has been gone away. So we should read the latest judgment. You must read that the latest. What is the latest position of law? Whenever that some subject 499. So you will have to first to see that what is the Supreme Court as on today the 499. That is the first foremost research to be done. Forget about that others which is we did that. Who did that? What is the latest position? Go to the Supreme Court judgment, section 499. So what is the judgment? If it is in the 5-bench judgment of the latest, then it is a damn sure no further judgment thereafter. Because it's a constitutional bench has been 5-bench bench. That means it's a constitutional bench. So that bench has been, once it has been decided, it is a rule of law. It will that authority which will be applicable, and it is everywhere, it is applicable all over India. So that is the latest judgment you must read. So continue to keep on reading that one judgment on every day. So what will happen? You will keep on updating that. It's not that whatever it is written in the books you should read. No. When you are come to practice, you feel that means then whatever I learned in the books, there is no use. Sometimes you also feel in that line of practice when you are seeing that these are not, I am not getting that means whatever that means it's a kind of the legal provisions and everything, that is sometimes that only that 5% of those provisions are applicable to the your case, which is whenever that if you are practicing a civil case, the civil practice, the criminal side, the criminal practicing that. So everything should be make it in the practical. If some client has approached you, so first to listen carefully what is their problem. Don't jump into the conclusion that this would be that. Don't give any assurance to the client. We are the officers of the court. We must know that means where is our limitations. Both the parties are there. We are not the judge to judge that what's the final conclusion of it. So we must inform. Listen carefully. That patience is more first and foremost. Patience should be there. Let the client, whoever comes to you, should listen carefully first. Make the notes. After that, ask these questions. Whatever that means. So then you got that means this is the case. What would be the relevant provisions of what is a remedy available? Once that remedy available, then make the petition, draft the petition, and if it is within the 4th quarter of the law, then make your best suggestions to client, best option. After research, then you start appearing with it. This is the way that means we need to read it and we need to approach. Otherwise, what will happen that it's kind of a exercise which has been doing that means there is no purpose. Hotel exercise, what we can do. The lawyer should always, it's a competitive field. Whatever happens, now it is not the 4 corner. Now we are going out in the public, serving as a profession. It's a noble profession. Then we must, that means there are competition are there in the law field also. Whoever the best service is be given, they will get the more matters. They will approach the more clients. So be proactive. That I can say that be proactive. Sure. In the court hall, not only the lawyers, there are litigants also coming. It is only purely your, what is called, your performance. When you perform the court well, obviously the client must be then they will take your visiting card. That is the client. That is your asset. So that's only that. You need not find anyone. Perform the court well, make sure that court has been recognized you. Gradually that will be done. So after the 5 years, then you will that the income will be generated. So then next 5 years, that means you need not think about the income. Income will follow.
Sir, what was your journey, sir?
My journey, that means it's back. That is, we will take some time, but I would say that I studied my graduation in Kerala. My two brothers are here in that, both are lawyers. My wife is also lawyer. I only for doing the LLB I came to Bombay. I wanted to do the LLB. In 2000, I came over here. First I am a BCom graduate. So obviously the BCom graduate, what we do? Okay, go to ICWA or CA. This is the normal standard of that point of time. Nowadays I think changed. There are people that started doing arts and other things, psychology and other things. But when I started that ICWA, I joined ICWA. Now I realize that I can't do job. I have to only do the ICWA. ICWA, that means you need a 100% concentration. Otherwise, then I wanted to do some job. So then, what is the best profession? Yes, I have to do LLB. LLB, if you do that, means you can work with some lawyer also. I started that means I joined LLB. Immediately I joined. After 2 years, I joined with some law. So what happened that why I do is as an intern, only to assisting, no intern, nothing. Even if there is a traveling expenses, if you get, then you have no happens. Otherwise, you have to spend it from your pocket. When you start that journey, then there is a 2 years of that experience as an intern. So our 2 years is very crucial for me because I got to know that means what is the court procedure. There are filing procedures. There are procedures which are that how to make that apply certificate of opinion, how to plagiarization, how to stitch it. Everything that is in the for 2 years it is very easy for me to understand. So then after that 2 years, that means I got the LLB. That time that means there was no bar exam. Immediately that means it started appearing. So I need not wait for that means for my turn. So immediately that means year out I started practicing. So that opportunity I got it because of that joined as I learned with some law firm. I continued that particular law firm. That is one Mr. T.N. Tripathi. He was one of the attorney wherein I started working for 8 years for the same law firm, including internship of 2 years. So then after that completion and then I didn't say, my senior didn't say anything that are you going to start practice? He never said that. Because I am handling the case, then it is for advantage for him. So he never said that, no, you don't leave. You leave, then he never said that. But I feel that then it is the right time. In 2010 I left that. But with happy. Then he saying I was about to say, you are going to leave. So when he got that, I got the 70 matters on my hands. During that the practice, I also have some matters. I got 70 matters. I thought that yes, it is a good enough handsome matters. So start practicing. So that practice, that means I thought that I was on the similar question. If the 70 matters over, then what will happen? If I started practicing, so then 70 that means it has been multiplied. I never look back what is there. So then it's 100, 500, thousands matters that has been found. So then last 22 years, I got a handsome matters and then one of the leading national banks panel like me. I am advisor to that. So why I am saying that it's a gradually investment. It is not that all of a sudden you can earn something or you can become a good lawyer. I would say that systematic way. Don't leave this profession in between and also don't break. Because sometimes the girls who have started practicing after the marriage, they used to leave that profession or the break is there. So what happens that while there is a break, it will be difficult for you to update your knowledge. When you are in practice, that means you can update the knowledge because you are sitting in the court not only for your matter, other matters are also there. You are just pointing, you are just listening what is happening with other matters which is nowhere related to your case. But it is gathering that means information, knowledge, updating. So this was my, now I started my law firm in 2010. I have around 5-6 employees are there, juries are working with me. I have an office there in Thane and Pune also. I hope that means yes of course that means everything is going well.
We really appreciate that you have given a lot of time to our students and you have given the valuable information and knowledge on how to approach before the court, because this practical information can be given by you only. Like, so our student has get the theoretical and this time we have the practical aspect also. sir and Sanjay sir to please join the guests so that we can start our prize distribution ceremony.
Yes, I invite first Karan Ranveer. Kindly clap. First I invite team number 1, Karan Ranveer, BA LLB, third year, BCG College. Second team, Raja Ranjan, Chhatrapati Shivaji Maharaj University, BA LLB, second year. Best researcher, Mr. Raja Ranjan. Now I invite third team, Raksha Kashyap, Winfield, BA, DLS, LLB, third year. And best speaker.
So what is our best speaker?
Our student, now you have a challenge. Now only two teams left, first and second. Can anybody guess who is going to win the first and who is the second?
First runner-up. Yes,
First
runner-up.
runner-up. Any guess? Any guess?
Runner-up. For runner-up.
Yeah.
The runner-up, sir.
Runner-up is now your time. Runner-up is Digambar Sonamani. Mr. Rahul Arora and Madhuri Shinde. Big clapping for the runner-up team. All India's LLB third year, Chhatrapati Shivaji College, Chhatrapati Shivaji Maharaj University. Runner-up of the day.
Excuse me. सामने अब आप तीनों खड़े हो जाए तीनों खड़े हो सामने सर सामने सामने
Now it is time to open the curtain for the final participants. It is not other than Anushka. BA LLB third year, Adib, BA LLB fourth year,
Pratik,
Yeah.
DA is in first year. He is very big for the first year student.
अनुष्का सामने
Thank you so much. As you have already said that none.
साथ ही साथ मैं धन्यवाद दूंगा अपने एडवोकेट संजय सर्राफ सर को, पीयूष माहेश्वरी मैम को और मेरी जो टीम काम कर रही है उसके लिए, उन सभी छात्रों को जो बहुत ही मेहनत से, बहुत ही परिश्रम से इस काम को किया है। और हमें उम्मीद है कि आगे नेशनल मूट कोर्ट हम जल्दी ही डिक्लेयर करेंगे। सभी लोगों को, जिन लोगों ने यहाँ पे आकर के अपना अमूल्य समय दिया है और हम लोगों के साथ बैठ करके काम किया है। बाहर से जो मेरी टीम आई है, बाहर के जो लोग आए हैं, उनको भी मैं धन्यवाद दूंगा। बहुत सारे डिपार्टमेंट से लोग मेरे यहाँ आए हुए हैं, उनको भी धन्यवाद दूंगा। उन लोगों ने इस मूट कोर्ट को देखा और आपका सुझाव चाहिए कि इसमें और क्या हम कर सकते हैं जो बेटर हो फ्यूचर के लिए मेरे। तो इसी के साथ साथ मैं अपने सभी गेस्ट, चीफ गेस्ट और अपने कलीग सारे लोगों को धन्यवाद दूंगा। बहुत बहुत धन्यवाद।